Have you ever wondered when exactly legal personhood begins in South Africa? It's a fascinating concept, this idea of legal personality. It's the point at which an individual is recognized by the law, gaining rights and responsibilities within the legal sphere. In South Africa, the process starts with something as simple yet profound as a birth registration. This act of officially recording a newborn's existence is the foundation of their legal identity. It's like a passport to the world of law, opening the door to a host of rights and protections. And it's not just about rights, it's about responsibilities too, paving the way for an individual's interaction with the law throughout their lifetime. But this raises an intriguing question. If birth registration is the genesis of legal personality, what about those who are yet to be born? So, birth registration is the first step in establishing legal personality, but what about those not yet born? The law in South Africa recognizes the interests of those yet to be born through a concept known as the Nasciturus fiction. This principle, steeped in Roman law, is a legal doctrine that allows for the rights of an unborn person to be protected under the law. It's a fascinating concept that gives the unborn a legal status, albeit a somewhat unusual one. In its original Latin, Nasciturus translates to "he who is about to be born." The Nasciturus fiction therefore posits that for certain legal purposes the unborn is deemed to be already born. It's a fiction, yes, but one that serves a very real purpose: the protection of the unborn's interests. But how does this apply in South Africa? Well, South African law has long recognized the Nasciturus fiction. The principle is applied in various fields of law such as succession law, property law, and even tort law. For instance, if a person passes away and leaves their estate to their unborn child, the Nasciturus fiction ensures that the child's inheritance is protected, even before they are born. The Nasciturus fiction also extends to the realm of contracts. An unborn child can be the beneficiary of a contract, with their rights being protected by the law. This is particularly relevant in cases involving trust funds or insurance policies. However, it's important to note that the Nasciturus fiction doesn't grant the unborn full legal personality. The unborn cannot, for example, be a party to a lawsuit or own property in their own right. Their legal status is contingent, dependent on their being born alive. This raises complex questions about the extent to which the law can and should protect the unborn. Do these protections imply that the unborn are sometimes considered legal subjects? And if so, what are the implications of this for issues such as abortion rights? The Nasciturus fiction ensures that the unborn are not left unprotected by the law, but its application is not without its complexities. In our next scene, we'll delve further into these complexities and explore the practical application of the Nasciturus fiction in the South African legal landscape. The Nasciturus fiction is not applied universally in all situations. It has a specific field of application. This legal principle, originating from Roman law, has found its way into the South African legal system, but its application is not an all-encompassing blanket. Where it is applied, it is done so with specific intent and in certain situations. Firstly, we see the application of the Nasciturus fiction in the realm of inheritance. This principle allows an unborn child, provided they are subsequently born alive, to inherit as if they were already born at the time of the deceased's death. This ensures that the rights and interests of the unborn child are protected in situations where their birth follows the demise of a potential benefactor. The principle extends to the law of delict as well. In the instance of prenatal injuries, an unborn child can claim damages once they are born alive. This is a clear illustration of how the Nasciturus fiction allows the law to protect those who are yet to be born, but are already recognized as potential bearers of rights. Case law has further expounded on the application of the Nasciturus fiction. In the groundbreaking case of Christian Lawyers Association of SA and others v. Minister of Health and others, the court acknowledged the Nasciturus fiction but refrained from declaring the unborn as bearers of rights. The court emphasized that the fiction does not provide the unborn with an independent legal personality, but it does allow for the protection of their potential interests. In contrast, the case of ex parte Bodil Steenkamp dealt with the question of whether an unborn child could be regarded as a dependent for the purposes of the Maintenance Act. The court concluded that the Nasciturus fiction could not be extended to this context, demonstrating the limitations of the principle. So, while the Nasciturus fiction is a powerful tool in the protection of the unborn, its application is nuanced and context-specific. It's a principle that underscores the delicate balance between the rights of the unborn and the practical considerations of law. Does the protection of the Nasciturus interest imply that the unborn human being is sometimes a legal subject? This question ignites a spirited debate among legal scholars, ethicists, and policymakers alike. On one hand, proponents argue that unborn children should be considered legal subjects. They cite the Nasciturus fiction, a legal principle that, although originating from Roman law, has found application in modern South African law. The Nasciturus fiction postulates that, for some purposes, an unborn child should be regarded as if it were already born. This principle primarily comes into play in inheritance laws, where an unborn child can be considered a rightful heir, provided they are born alive and viable. On the flip side, opponents counter that recognizing the unborn as legal subjects could lead to a slippery slope, opening a Pandora's box of legal and ethical dilemmas. They worry about potential conflicts between the rights of the mother and the unborn child, especially in sensitive areas such as abortion rights and medical treatment decisions. So where does South African law stand on this contentious issue? Well, the answer is not as straightforward as one might hope. The South African law seems to navigate a middle ground, recognizing the interests of the unborn through the Nasciturus fiction, yet stopping short of granting them full legal subjectivity. This is evident in the Births and Deaths Registration Act, which requires the registration of a child's birth within 30 days, thereby indirectly acknowledging the legal existence of the unborn. The law also takes into account the interests of the unborn in areas such as property law and torts. For instance, an unborn child has the potential right to claim damages for prenatal injuries, provided they are born alive and viable. In conclusion, the South African law walks a tightrope, seeking to balance the rights and interests of the mother with those of the unborn. While the debate continues, it is clear that the law in South Africa seeks to protect the interests of the unborn, albeit indirectly. Our exploration of the beginning of legal personality in South Africa has taken us from birth registration to the complexities of the Nasciturus fiction. We've delved into the pivotal role of birth registration, as the first formal recognition of an individual by the state, granting them legal rights and responsibilities. We've also discovered the fascinating concept of the Nasciturus fiction, a legal principle that safeguards the interests of the unborn. This principle, though not without its complexities, ensures that the unborn are not left unprotected in matters of inheritance and other legal rights. Lastly, we've considered the contentious question of whether the unborn can be considered legal subjects. This is a topic that not only invokes legal principles, also raises profound ethical and societal questions. As we can see, the question of when legal personality begins in South Africa is not a simple one, but a complex interplay of law, ethics, and societal values. In our next video, we will explore the end of legal personality. Stay tuned.